This bill seeks to punish and also deter one of the most heinous and vile acts imaginable, that of sexual battery on a young child. A crime so monstrous and horrific there can be no tolerance for the perpetrators in a civilized society. The bill amends Section 794.011 of the Florida statutes to authorize a sentence of death for a defendant found guilty of sexual battery on a child under the age of 12. The bill also creates a new section laying out a separate sentencing hearing to determine whether a defendant convicted under this section shall be sentenced to death. Included is a detailed list of aggravating factors that a jury must unanimously determine the existence of at least two, which is one more than what is currently required in capital cases, and both must be proven beyond a reasonable doubt and unanimously. In addition, if the jury recommends death, the judge has judicial discretion to instead impose a life sentence. And finally, this bill expresses the viewpoint of this legislature as the elected representatives of the people of Florida that the previous holdings of Buford v. State and Kennedy v. Louisiana were wrongly decided and were an egregious infringement of this state's power to punish the most heinous of crimes, and reasserts our sovereign authority to punish these unspeakable crimes in the manner that we deem most appropriate, and that is the bill, Mr. Speaker.
I rarely rise in this chamber unless I believe that my voice is worthy of the cause, and I rise today motivated by the defense of children, but mostly the defense of logic. We make the law. The courts may interpret what they can, and then they bring us case laws, but make no doubt about it. Any 1L can tell you that we make the law. And when we step into the lawmaking ability, we rule. But let's go further, because I cannot believe that we stand here today debating whether or not on detail we're going to defend a child. Yes, this is not murder. It's worse. When you rape a child, you kill that child's spirit. That rape lasts with every moment that child closes their eyes. And you tell me, oh, it doesn't meet the standard. Well, then whatever would meet a standard? If you will not rise with a child, you will fall with the rapist. Mr. Speaker, this is a good bill. There should be no debate, and you should vote up.
Leader Grant, you're recognized in debate.
Thank you, Mr. Speaker. We waive our time.
Leader Grant, having yielded the remainder of his time, the question now will recur. Representative Baker, you're recognized to close on your bill.
Thank you, Mr. Speaker. I want to thank all the members for the healthy debate we've had here today and all the discussions that I've had with a lot of the members over the last few weeks. All of the debate pretty much focused on the constitutionality of this bill. And like I said before, we know that throughout the history of this country, there have been numerous cases that were very wrongly decided and then were later overturned. The Supreme Court is not legally bound by its prior rulings. They give them some deference, but they recognize that the court sometimes gets it wrong. And the narrow 5-4 majority in the Kennedy case got it wrong. The majority opinion in Gregg v. Georgia, the landmark case for the death penalty, said capital punishment is, quote, an expression of the community's belief that certain crimes are themselves so grievous an affront to humanity that the only adequate response may be the penalty of death. Here I want to emphasize community's belief, because that is exactly why the court got it wrong. We, as the elected representatives of the people of Florida, get to determine the adequate punishment for these heinous crimes, not 5 unelected judges who use their independent judgment, who use their personal opinion to determine what our standard of decency is. The court drew a bright line rule in the sand. They made an issue black and white that is not black and white. There can be no blanket policy on this issue. As Justice Alito said in his dissent in the Kennedy case, What the court holds today is no matter how young the child, no matter how many times the child is raped, no matter how many children the perpetrator rapes, no matter how sadistic the crime, no matter how much physical or psychological trauma is inflicted, and no matter how heinous the perpetrator's prior criminal record may be, they cannot be put to death. According to the statistics from the Department of Justice, a child sex abuser will commit an average of 117 separate offenses of sexual abuse before they are caught. 117. Members, the Kennedy court got it wrong. And that brings me back to what this bill is really about. The fact that a person could look at a child and intentionally defile and abuse that child for sexual gratification is demonic. The person is morally depraved, morally depraved, I would say, than most that pull the trigger. The rape of a child is a deliberate, methodical act. It doesn't happen accidentally. We are talking about today is the punishment for someone who would rape a small child. What would you want to do if this happened to your child? I know what I would want to do. It's a natural instinct because it is a crime that is so horrific and so monstrous that it is deserving of the ultimate punishment. I would rather lay down my own life than this happened to my child. My precious 4-year-old girl, my sweet 5-year-old boy. Raping a small child rips away their soul. It fundamentally alters the trajectory of their life. It effectively and functionally murders them. They are no longer the same child, and you can never undo what happens to that child. Members, I'm going to close with this. There is no earthly redemption for somebody who rapes a small child. Only God can save them. And in Florida, we should be eager to arrange that meeting. Members, I ask for your support, and with that, I close.
95 yeas, 14 nays, Mr. Speaker.
Show the bill passes.